Exception to fundamental right. First, saving of law providing for acquisitions of estates, etc. Article 31st issues five categories of laws for being challenged and invalidated on the ground of contraventions of the fundamental right conferred by Article 14 equality before law and equal protection of law, and Article 19 protection of six rights in respect of speech, assembly, movement, etc. They are related to agriculture, land reforms, industry, and commerce and include the following: A. Acquisitions of estates and related rights by the state. B. Taking over the management of properties by the state. C. Amalgamations of the corporations. D. Extinguishment or modifications of rights or directors or shareholders of corporation, and E. Extinguishment or modification of meaning leases. Article 31st does not immunize a state law from judicial review unless it has been reserved for the President's considerations and has received his assent. This article also provides for the payment of compensation at market value when the state acquires the land held by a person under his personal cultivations and the land is within the statutory ceiling limit. Second, validation of certain acts and regulations. Article 31b saves the act and regulations included in the ninth schedule from being challenged and invalidated on the ground of contraventions of any of the fundamental rights. Thus, the scope of Article 31b is wider than Article 31. Article 31b immunises any law included in the ninth schedule from all the fundamental rights, whether or not the law falls under any of the five categories specified in Article 31. However, in a significant judgment delivered in IR Colio case, the Supreme Court ruled that there could not be any blanket immunity from judicial review of law included in the ninth schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the ninth schedule. It said that the laws placed under the ninth schedule after 20 April 1973 are open to challenge in court if they violated fundamental rights guaranteed under Article 14, 15, 19 and 21 of the basic structure of the Constitution. It was on April 24, 1973 that the Supreme Court first propounded the doctrine of basic structure or basic feature of the Constitution in its landmark verdict in the Keshwanand Bharati case. Originally in 1951, the ninth schedule contained only 13 acts and regulations, but at present in 2019, their number is 282. Of these, the act and regulation of the state legislature deal with land reforms and abolitions of the Jamindari system, and that of the parliament deal with other matter. Saving of laws giving effect to certain directive principle. Article 31c, as interested by the 25th Amendment Act of 1971, contained the following two provisions. A. No law that seeks to implement the socialistic directive principles specified in Article 39b or C shall be void on the ground of contraventions of the fundamental right conferred by Article 14, equality before law and equal protections of law, or Article 19, protection of six rights in respect of speech, assembly, movement. B. No law containing a declaration that it is a forgiving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Keshwanand Bharati case 1973, the Supreme Court declared the above second provision of Article 31c and unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31c was held to be constitutional and valid. The 42nd Amendment Act 1976 extended the scope of the above first provision of Article 31c by including within its protection any law to implement any of the directions any law principle specified in Part 4 of the Constitution and not merely in Article 39b or c. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case 1980. Criticism of fundamental right. The fundamental rights inherent in Part 3 of the Constitution have met A wide and varied criticism. The argument of the critics are: first, excessive limitations. They are subjected to innumerable exceptions, restrictions, qualifications, and explanations. Hence, these critics remark that the Constitution grants fundamental right with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental right should be renamed as Limitation on Fundamental Rights and Limitation thereon. Second, no social and economic rights. The list is not comprehensive as it mainly consists of political rights. It makes no provision for important social and economic rights like right to social security, right to work, right to employment, right to rest and right leisure, and so on. These rights are made available to the citizens of advanced democratic countries. Also, the socialistic constitutions of erstwhile USSR or China provided for such rights. Third, no clarity. They are stated in a vague, indefinite, and ambiguous manner. The various phrases and words used in the chapter, like public order, minorities, reasonable restriction, public interest, and so on, are not clearly defined. The language used to describe them is very complicated and beyond the comprehensions of the common man. It is alleged that the Constitution was made by the lawyers. For the lawyers, Sir Ivor Jennings called the Constitution of India a paradise for lawyers. Fourth, no permanency. They are not they are not scrutinised or immutable as the Parliament can curtail or abolish them. As for example, the abolition of the fundamental right to property in 1978. Hence, they can become a play tool in the hands of politicians have majority support in the Parliament. The judicially innovated doctrine of basic structure is the only limitation on the authority of Parliament to curtail or abolish the fundamental right. Fifth, suspension during emergency. The suspension of their enforcement during the operation of national emergency, except Article 20 and 21, is another blot on the efficiency of these rights. This provision cuts at the roots of democratic system in the country by placing the right of the millions of innocent people in continuous jeopardy. According to the critics, the fundamental rights should be enjoyable in all situations, emergency or no emergency. Expensive remedy. Sixth, the judiciary has been made responsible for defending and protecting these rights against the interference of the legislature and executive. However, the judicial process is too expensive and hinders the common man from getting his rights enforced through the courts. Hence, the critics say that the right benefits mainly the rich section of the Indian society. Seventh, preventive detection. The critics assert that the provision for preventive detection, Article 22, takes away the spirit and substance of the chapter on fundamental rights. It confers arbitrary powers on the state and negates individual liberty. It justifies the criticism that the Constitution of India deals for more with the right of the state against the individual than with the rights of the individual against the state. Notably, no democratic country in the world has made preventive detention as an integral part of their constitution as has been made in India. Eighth, no consistent philosophy. According to some critics, the chapter on fundamental right is not the product of any philosophical principle. Sir Ivor Jennings expressed this view when he said that the fundamental rights proclaimed by the Indian constitution are based on no consistent philosophy. The critics say that this creates difficulty for the Supreme Court and the High Court is interpreting the fundamental right. Significance of fundamental right. In spite of the above criticism and shortcomings, the fundamental rights are significant in the following respect. First, they constitute the bedrock of democratic system in the country. Second, they provide necessary conditions for the material and moral protection of man. Third, they serve as a formidable bulwark of the individual liberty. Fourth, they facilitate the establishment of rule of law in the country. Fifth, they protect the interest of minorities and weaker section of society. Sixth, they strengthen the secular fabric of the Indian state. Seventh, they check the observance of the authority of the government. Eighth, they lay down the foundation stone of social equality and social justice. Ninth, they ensure the dignity and respect of individual. Tenth, they facilitate the participation of people in the political and the administrative process. Rights outside Part 3rd. Beside the fundamental right included in Part 3rd, there are certain other rights contained in other part of the Constitution. These rights are known as constitutional right or legal right or non-fundamental right. They are: first, no tax shall be levied or collected except by authority of law. Article 265 in Part 12. Second, no person shall be deprived of his property save by authority of law. Article 300A in Part 12. Third, trade, commerce, and intercourse throughout the territory of India shall be free. Article 301 in Part 13. Even though the above rights are also equally justicable, they are different from the fundamental right. In case of violation of fundamental right, the aggrieved person can directly move the Supreme Court for its enforcement under Article 32, which is in itself a fundamental right. But in case of violation of the above rights, the aggrieved person cannot avail this constitutional remedy. He can move the High Court by an ordinary suit or under Article 226 writ jurisdiction of High Court.